Good morning, and I welcome you to the 15th breakfast we've held at the Lanesboro on topical events. Few could be as topical as the one we're dealing with this morning. This case really does represent a perfect storm of issues that flow from the increasing pace of repressive legislation that has resulted from the attack on the Twin Towers. We are living in a state of permanent emergency where Western countries, and certainly Eastern countries, have really attacked entrenched human rights under a variety of guises to further limit the personal sphere. And unfortunately, that didn't stop with the Patriot Act. It has continued in the United States apace. It has accelerated in this country with its special courts, with the leader of the SFO attempting to destroy some of the guarantees dating back to the 12th century in the UK, attacking, as he presently is, the rights one has in this country for legal privilege. So in light of this growing storm, there could be few things as important to discuss today as the Apple case, and we are very fortunate indeed that our friend and colleague, Judge Larson, has flown in literally just for this breakfast from LA to speak with us. Judge Larson has been practicing at the bar California for 26 years. For 10 years he was a federal prosecutor, rising to become chief of the organized crime section in Los Angeles, specializing on Russian organized crime, which I barely knew existed.
Now you know how we met.
Yes. 10 years a federal judge appointed by perhaps a president ennobled by his defense of human rights, George W. Bush, and then for the last 6 years, a litigation partner at Arent Fox, a national firm in the United States based out of Washington, and now, very recently, principal of his own spectacular law firm in Los Angeles, Larson O'Brien, who my firm in D.C. and London is sort of unofficially affiliating with in respect to a number of major cases we have going on together. Judge Larson and I have agreed he is going to present some opening remarks. Then I am going to make a few pointed remarks and questions based on my sympathy with Apple's perspective. For those of you who are not aware, Judge Larson represents, I guess, the majority of the families of the San Bernadino massacre, and in fact has filed an amicus brief in the present case. Judge Larson.
Well, thank you very much. Well, thank you for joining me this morning. I really appreciate it, and Bob for setting this up. I did know that Bob made a not so subtle indication of which side he supports in this thing by leaving deposited one single apple on everyone's chair. I myself have the ubiquitous iPhone, and so I'm just waiting for it to get shut down given my current activities. It's an awkward position for me to be in. As Bob indicated, I spent 10 years as a prosecutor and 10 years as a federal judge. These last 6 years have been largely devoted on the defense side of the house. In fact, I'm flying back this afternoon because I have a hearing tomorrow morning in San Bernadino Superior Court, literally less than a mile from the site of the December 2nd terrorist attack, where I will be challenging a search warrant brought in a unrelated corruption case out in San Bernadino. And then on April 7th, I have a date with the Ninth Circuit Court of Appeal in Pasadena, which is is the Federal Court of Appeal on the West Coast, where I'll be challenging a search warrant that was issued by the same U.S. Attorney's Office who is now pursuing this particular order from Apple. And that's the usual side that I find myself on these days. But about 4 weeks ago, I received a call from the United States Attorney in Los Angeles, Eileen Decker, and she is someone that I had worked together when I was in the prosecutor's office back in the 90s. And she asked me if I would consider representing the families of the victims in this case. And to be honest, at that point, I neither had a particular position nor did I have a real good understanding of the issues involved. But being a good American, I said yes when Uncle Sam called, and I endeavored to meet with the victims, their families. Ended up entering into engagements with the majority of the families of those who had been killed. 14 were killed on December 2nd, and we're representing a majority of those families. And in any event, I've spent, needless to say, some time since then considering this issue. And I do realize that not only do the majority of the American people, but the majority of my own children have taken the position that Apple is in the right on this case. But I really think this isn't quite the case that it's being made out to be. And I'm going to make some opening remarks, and then we're going to turn this into a bit of a back and forth. But I just wanted to set out a few things, because I know the title of this morning's breakfast is the privacy case of the decade. And first and foremost, I think it's important to keep in mind that at least as far as this legal case to do, it has little to do with privacy. Privacy is something which, of course, is massively important to us all, whether we're Americans or British or whoever we are. But this case involves a particular iPhone that was not owned by the dead terrorist in question. It was actually owned by the county of San Bernadino for whom he worked. And the county of San Bernadino, who owns this phone, had given consent to have it searched. In addition, Mr. Farouk, when he obtained the iPhone from the county of San Bernardino, signed an employment agreement in which he consented to have the iPhone searched. So if this were in any other circumstance, if, for example, if Mr. Farouk hadn't died in a hail of bullets on December 2nd after killing these 14 individuals, there is no question that he would have been required to provide that information. That was not his phone. What this is, under American parlance, is a Fourth Amendment issue. Our Fourth Amendment, as I'm sure most of you know, is what regulates the government's ability to exercise or execute warrants to obtain criminal evidence. One of the bedrock principles of American jurisprudence is that you cannot hide criminal evidence. You can't hide it in your bedroom. You can't hide it in a lockbox under your bed. You can't hide it in your safety deposit box. You can't hide it in such a way that it is completely immune from government obtaining it, provided that the government complies with the Fourth Amendment. The Fourth Amendment permits reasonable searches and seizures. They must be based on a warrant, an affidavit, that meets certain specifications, and a warrant must issue by a neutral magistrate. And if those conditions are met, the government has the authority to go into the most private reaches of your home, of your life, and obtain criminal evidence. And in this case, the evidence is not contained in some lockbox in a log cabin as it might be in 1789, but the evidence is in this iPhone. And the government has asked for and received an order to obtain that evidence. Of course, the wrinkle here is that there's a lock on this iPhone. And it's not the type of lock which the government would ordinarily use a pair of cutters to undo. It's an encrypted code that only Apple, apparently, is in a position to decrypt. We'll be getting into in a few moments. The government has obtained an order for Apple to do just that. So that's a little bit of the backdrop of where we are and just some thoughts on how we've gotten to where we are. It's certainly an important case. It's one that has dominated the news, well, besides Donald Trump and certain features of Donald Trump, has dominated the news in the United States for the last month or so.
Well, I think a good place to begin in a dialogue on this issue is with a discussion of something called the All Writs Act. Why don't you explain, because this is a an act that dates from 1789.
It's an old act, almost as old as the Constitution itself. In fact, it was passed as part of the Judiciary Act of 1789, one of the first pieces of legislation that the new Congress enacted after the Constitution. And it basically provided a codification of a long-standing common law rule, which we got from good old England, that courts have the power to enforce their warrants. And it basically provided, quote, courts shall have the power to issue all writs necessary to exercise their jurisdiction, and it has been used repeatedly over the course of the last 200 plus years, basically for courts to enforce their jurisdiction. When they needed the cooperation, they need the assistance of someone or something. Now there's limitations on that, particularly in the context of criminal investigations. And the most important limitation that has been upheld consistently is you cannot force someone to do something that incriminates themselves, because that would run afoul of the Fifth Amendment, the right against self-incrimination. In this case, there is no suggestion by Apple, the government, or anybody else that Apple has done anything wrong. So for them to comply with this order in no way incriminates them. But yes, that's the All Writs Act, which is the statutory mechanism that is being used to require Apple to conduct the decryption.
Now, your first hint that the government may be in trouble on this case is that they and Judge Larson are referring to an act that was passed about 75 years before Alexander Graham Bell existed. And I'm going to read you the conclusion of Judge Ornstein, magistrate judge in the United States District Court, Eastern District of New York, otherwise, to those born in New York, Brooklyn, where the magistrate judge kind of makes this case about more than one iPhone. He states, "In deciding this motion, I offer no opinion as to whether, in the circumstances of this case or others, the government's legitimate interest in ensuring that no door is too strong to resist lawful entry should prevail against the equally legitimate societal interests arrayed against it here. Those competing values extend beyond the individual's interest in vindicating reasonable expectations of privacy, which is not directly implicated where, as here, it must give way to the mandate of a lawful warrant. They include the commercial interest in conducting a lawful business as its owners deem most productive, free of potentially harmful government intrusion, and the far more fundamental and universal interest important to individuals as a matter of safety, to businesses as a matter of competitive fairness, and to society as a whole as a matter of national security, in shielding sensitive, electronically stored data from the myriad harms, great and small, that unauthorized access and misuse can cause. How best to balance those interests is a matter of critical import to our society, and the need for an answer becomes more pressing daily as the tide of technological advance flows ever farther past the boundaries of what seemed possible even a few decades ago. But that debate must happen today, and it must take place among legislators who are equipped to consider the technological and cultural realities of a world their predecessors could not begin to conceive. It would betray our constitutional heritage and our people's claim to democratic governance for a judge to pretend that our founders already had that debate and ended it in 1789. Many people believe this case actually implicates the separation of powers, because it is very clear that the FBI and its director actually withdrew the prospect of bringing legislation on this issue to Congress because they could not get anyone to sponsor the legislation. And the FBI have basically opportunistically brought this case, hoping to use the judiciary in a scenario where they could not use the legislative branch to deal with this massive issue of policy. So, Judge, when you speak of just one case, clearly Brooklyn doesn't agree.
Brooklyn doesn't agree, and you know, I think it kind of proves the point, because the Central District does agree. And it almost, the adverse decision out of a magistrate judge in Brooklyn contradicting a decision of a magistrate judge in Los Angeles, or actually in Riverside, where this magistrate judge is located, demonstrates that different cases are going to be decided in different ways, that the precedent in one magistrate judge is not going to affect a magistrate judge across the country and vice versa. It's absolutely correct that ultimately this issue needs to be decided by Congress. And I think one of the good outgrowths of this robust debate that we've had is that it is going to force Congress to address this issue. But in the meantime, courts do what courts do. They decide individual cases before them. Our criminal justice system, much like yours, is based on a case-by-case approach. Because a person accused of bank robbery is convicted in one court of bank robbery, it doesn't mean that everyone accused of bank robbery is going to be convicted of bank robbery. You evaluate the circumstances of the individual cases. The Supreme Court addressed this All Writs Act, which has come under the same criticism that Bob makes about its age. You know, I would make one point: the only thing older than the All Writs Act is the Constitution, and we don't throw that out because it's rather old. But the Supreme Court wrote this. It said, "The writ must be agreeable to the usages and principles of law, a term which is unlimited by the common law, or interestingly, the English law. And since law is not a static concept, but expands and develops as new problems arise, we do not believe that the forms of writs authorized by the All Writs Act are only those recognized in this country in 1789, when the original Judiciary Act containing the substance of this section came into existence." The Supreme Court goes on, "In short, we do not read the All Writs Act as an ossification of the practice and procedure of more than a century and a half ago. Rather, it is a legislatively approved source of procedural instruments designed to achieve the rational ends of law. And in cases that have relied upon the All Writs Act since then, including the most recent case that came up just 2 years ago, it has emphasized that it provides for a common sense approach for courts to enforce their jurisdiction." And I think that's what's going on here. This really is about one iPhone. You know, no one's going to be able to use the precedent in this case to do anything else. And you go back to the Eastern District or the Southern District of New York or the District of Virginia or North Dakota or any place in between, and judges will be called upon to make the same circumstantial evaluation of whether or not the iPhone before them should in fact be opened up and whether or not Apple needs to comply.
Well, let me just say, and I'll speak to the youngest member of the audience here, Josh, to say this is what a great lawyer sounds like.
Well, Cheryl. Or John.
The truth of the matter is, this case can't be thought of as an individual case because its precedent value in terms of how it is instrumentalizing Apple as an aidor in the destruction of the privacy of this individual is something that would require specific legislative intent. When you are dealing with interpretation of the statute, of any statute, one of the things you have to look at is the proportionality of the invasion. I would argue, and I believe it's going to be argued and has been argued in the States, that there is an act in the United States body of law, CALEA,
Yep.
which specifically addresses this issue, specifically actually addresses encryption, and doesn't allow for anyone to argue that there is somehow a break or separation in the law that would allow the All Writs Act to fit in. The existence of CALEA, which deals specifically with this issue and doesn't mandate the broad measures to be directed against Apple, leaves a very strong argument open that this is not an appropriate case for the All Writs Act. As somebody who has spent a lot of time looking at another statute from that era, the Alien Tort Claim Act, I can tell you that, and the Alien Tort Claim Act, for those of you who are not familiar, is a U.S. act from around the same period, which has been used up until the recent Supreme Court case quite expansively to import into American law public international law of human rights. But the argument in the alien tort cases actually is the reverse of what you state. It actually says go back and look at what were those international crimes extant in that era. I believe that these specific sightings in Kalia and the fact that many people in the U.S. view this case as an issue of separation of powers, and when you add to it the opportunism of the FBI in literally withdrawing legislation relative to encryption and then bringing, in fact, the New York case was brought after, I think the individual's name is Feng, after he had decided to plead guilty. So there has been a lot of, if you will, forum shopping by the government in this case. And yes, arguably, Apple is being helped every day in a wider policy sense by looking like it's defending everybody's privacy rights, and certainly the Chinese and the Indians are applauding on the side that no backdoor is being handed over to Uncle Sam. But Stephen, I'd like you to address the issue of just one iPhone, because I think clearly what the magistrate judge is addressing, and I think what the reason all of us are here is not about the iPhone. It's about the bigger issues that this one case you're involved in could well decide.
No, absolutely. And you raised a couple of things that I want to address. First of all, Kalia. Kalia is what the Apple folks in their brief are relying heavily on in terms of saying that this already governs this issue. What Kalia provided was that telecommunication carriers involved in the quote-unquote transmission and switching of data must take certain measures in advance of court orders to ensure that their systems can, quote, isolate information to allow for the real-time interception of network communications. Kalia deals with networks, and particularly telephonic networks. That's not what is going on here. We're talking about a physical singular phone. It is not in any way affecting or trying to intercept anything on the network. This issue has been very clouded and conflated, and I think unfairly so. Kalia, I think by most accounts, does not apply in any way. What does apply, though, is some pretty clear precedent set both by the U.S. Supreme Court. There was a case out of New York called New York Telephone, and a case out of the Ninth Circuit called Mountain Bell. And these were cases that involved the pen register and trap and trace technology. I'm sure most of you are familiar with that. Pen register is a device that is imposed on a phone where government can basically record the numbers that the phone is dialing. This is not like the Title III wiretap interception where you're listening to the actual conversation. This is just recording the actual numbers. So they can put a pen register on your phone and they get literally a printout in real time of every phone number that you're dialing. And then a trap and trace device does basically the opposite. It traps and traces all incoming calls. Again, not the content of the call, but just the number that's being called. And it's very useful in organized crime, narcotics, terrorism prosecutions, where you want to establish networks of individuals, who's contacting who, what are the identities associated with the phone numbers. And in the United States, a court order is required for doing this. But when they first came online, when this technology first came out, it required the phone companies to reprogram their data management. And the same exact argument that is being made by Apple today, that's being made by Bob in this room, was made in these two cases. And in both instances, the court rejected it. And specifically, the Supreme Court case of New York Telephone, which dealt with the pen register, was an All Writs Act case. Using the All Writs Act case, the FBI and the Justice Department insisted that the telephone companies comply, and they had to develop not computer code, but they had to do some reprogramming. And it was the same, I would say, in principle as is taking place in this case here. So this notion of it being unprecedented and somehow setting some precedent that's going to be used in all these other cases, I think is belied by that recent 40-year history. The last point I need to touch upon is opportunism. Because if there's any opportunism going on here, I think the opportunism is really coming from the Apple side of the house. Apple, this is not the first rodeo that Apple's been asked to attend. They have done this scores of time without incident. This is just the first rodeo that they have made a protest at, and they've made a big deal about it. It comes on the heels, of course, of BlackBerry claiming that they're more safe. It comes on the heels of an effort to expand Apple into the Asian market. It comes on the heel of Apple bending over backwards to try to accommodate the Chinese government in basically uploading their information onto the Chinese system to comply with their requests for data and information. So if anyone is being opportunistic, I think it is Apple. I want to share with you a letter. I'm going to return to who I'm representing here, because I'm not representing the government. I'm not representing the FBI. I'm representing victims. And one of the most moving testimonies that I received was a letter by Mark Sandifer. Mark Sandifer was the father of one of the individuals who was shot and killed on December 2nd. And he wrote this letter. It was a personal letter that he wrote to the CEO of Apple, Tim Cook. I asked him if I could include it in our amicus brief to the court, and he gave me permission to do so. So it's now a part of the public record. And I'll just bear with me if you'll indulge me while I read this. He writes, "Our son, Larry Daniel Eugene Kaufman, was one of the 14 people killed in the terrorist shooting in San Bernadino. Daniel worked as an instructor, teaching people with disabilities the skills necessary to live independent lives. He was not what one would think of as a terrorist target of the Islamic State. I have attended private briefings that are held for the families of the victims. At these briefings, we learn firsthand what the public eventually learns. We are not privy to anything only the FBI knows, but we talk amongst ourselves about the horrors of that day. Some of the survivors come to these meetings pushing walkers or limping with canes. They are reminders to me of what they went through. We who lost our family members are reminders to them that it could have been worse. Several of the survivors tell me bone-chilling stories of where they were and what they saw. Some of them describe in precise detail laying on the floor, hiding under furniture, and the bodies of their co-workers. That they saw 3 assailants, not 2, walking around in heavy boots as they carried out their murders. Recovery of information from the iPhone in question may not lead to anything new, but what if there's evidence pointing to a third shooter? What if it leads to an unknown terrorist cell? What if others are attacked and you and I did nothing to prevent it?" This wasn't opportunism by the FBI. The FBI certainly did not create this, although I'm sure we'll be hearing from some conspiracy theorists that they did, just like the US government is responsible for 9/11 and France is responsible for the attacks there. This was a case that presented itself in very, very compelling reality. This is a particular iPhone in which there is no privacy interest. The terrorist who killed these 14 people is dead. He was using somebody else's iPhone who has consented to the search. This is a case that I cannot understand or explain, using all of my defense lawyer perspectives, why Apple has drawn the line in the sand.
Well, look, Josh, once again, I will tell you that a great lawyer will definitely use the voice of the victims to try to obscure the very protections all of us in this room need to sustain ourselves in modern life. One of the things the United States has not learned from Israel and other countries that face terror every day is that in the modern world, we are going to face many, many victims. The goal of terrorists is not just to kill the innocent. The goal of terrorists is to change our society and our values. The goal of the terrorists is to make us different people so that we behave in a way that is more repressive and create more people sympathetic to their causes. We need human rights and basic freedoms more today than we did before 9/11. If there is anything we have learned by empowering the government since 9/11, It is that the government is less competent. The government is less able to defend ourselves now than they were before. They have given up human intelligence in so many important areas to attempt to manage warfare by drone and technology. And what's happened is that we have murdered thousands and thousands of people, all too many of them innocent, because now President Obama has his own kill list. Now President Obama murders American citizens without any due process. And now President Obama sits by and lets the people of Syria die, and yet walks into a courtroom through the FBI to demand more and more of our freedoms in exchange for a less and less secure environment. My view is there is no one Apple case. There is no one iPhone. Each and every one of us today, because of this technology, are more connected than we ever were. What happens in a courtroom in San Bernadino is going to impact us with a government that we have here in this country that is completely insensitive to privacy rights, is continuously grasping. I was talking to an Australian yesterday about secret terror courts in Australia that are mind-boggling that they exist in Western society. So I go back to the case here. Kalia specifically addresses encryption. There is a section on encryption that states, a telecommunications carrier shall not be responsible for decrypting or ensuring the government's ability to decrypt. We are not all pawns of the government. We are not all instruments to assist the government to invade the privacy of our fellow citizens. We have individual standards that must be kept sacrosanct. Part of our individual rights and part of our corporate rights is not to be instrumentalized by an overarching government power. 3 days after this horrible bombing in Ankara, 3 months after the horror that we've seen in Paris, I recognize that the specter of terror is not receding, but it's growing. But, Stephen, I go back to say, with encryption specifically dealt with in Kalia, how do you infer the All Writs Act, and how do you make the argument that this is just one case when these issues that we're raising, I mean, Apple says that to fulfill the government search, they are going to be required, I read the statement of Apple, that they're going to be required to actually re-engineer the new iPhone and set up their own government software. And they're saying not only is it a massive job, but that once they do that, once they create this government path, it is only a matter of days or months before it falls into the wrong hands. It's a monster that they can't deconstruct. How do you address that?
Well, I first need to address Josh, because Josh, what you're seeing here is when a very good lawyer finds himself losing a debate, what he will do is accuse his opponent of doing something improper and then do that very thing saying himself. Now, he was just saying that I was obscuring the issue with the reading of this letter, and then you heard about President Obama's drone program, and then, God forbid, secret terror courts in Australia. Returning to the iPhone in question, and Kalia again, and the quotation that you take is accurate, and the government cannot impose encryption or decryption requirements, but again, that is on the network server. It is not, Kalia is limited, it is not something which applies to the physical phone itself, and I think that'll be borne out in the litigation going forward. But putting that issue aside, the Mountain Bell case that I referred to earlier, that was the Ninth Circuit case involving that trap and trace device. And what Mountain Bell came up with is a three-step process to make sure that this does not become abusive, that the use of the All Writs Act is cabined. And the three things that need to be done here, or the three standards, is first of all, the court must consider is how far removed is a party from the investigation. And in this case, Apple is very closely involved. It's their iPhone. They're the only ones that have this particular technology. There doesn't seem to be any question on that. The second issue is how unreasonable is the burden being imposed. And you make allusion to this, that Apple says, well, they got to go and they got to create this code. By their own declarations submitted in support of this case, they're estimating that it will take 6 of their workers 2 weeks to do this. Now, I understand 6 workers. If I had to devote 6 of my attorneys in my new law firm that only has 12 attorneys to 2 weeks, that would be a huge burden. We're talking about a company that has 100,000 employees, that had $200 million in revenue last year, whose revenue exceeds the operating budget of the state of California, as well as something like 3/4 of the countries in the world. This is not an undue burden on Apple. Apple is able to do this. They're able to come up with software for a particular phone. They advertise the fact, and they've been advertising it for quite some while, that each physical iPhone has its own unique ID, its ECID process, that is incorporated into the phone's operating system. And Mr. Hanna, who was one of the folks who submitted a declaration in support of their motion, indicated that the ECID personalizes the authorization for the requesting device. The government is not asking, and the court has not ordered that Apple turn over any of the encryption information. The order does not require any of the software that is created to do this decrypting be turned over. All they are looking for is the information on the phone itself. Imagine if you were a bank and you had a safety deposit box, and in that safety deposit box was criminal activity, and you created a lock on that. That was a self-destructing lock, something like out of Mission Impossible or something, that was going to blow up in 3 seconds or whatever, if someone tried to open it 10 times. The government would say, you're not removed from the investigation, you own the bank, it's not a burden on you to undo this. And the third factor is, how necessary is the assistance? And in this case, it is critical. Again, looking at the circumstances of this case and this iPhone, applying the All Writs Act here, I couldn't agree with Bob more. The United States has gone overboard. I oppose the Patriot Act. I have fought vociferously against abuse of search warrants. A few months ago, I filed a $27 million lawsuit, civil rights lawsuit, against the county of Ventura for abusive execution of search warrants. I mentioned that I have a hearing on Wednesday, another one in April, challenging the legality of search warrants. We must be vigilant in standing up for human rights, particularly in this era of terror, because we could end up sacrificing that which we're trying to defend. I get that, and I believe in that in spades. It's about balancing. It's about balancing the interests of, on the one hand, national security, our civil and constitutional rights, and the interests in law enforcement. I think the judge in Riverside is doing that in this particular case. And fair enough, maybe the judge in Brooklyn did it in that particular case. And maybe a third judge may come out separately. But as long as we respect the rule of law, as long as judges are attempting to struggle with these balancing issues and considering the facts of their cases, I feel pretty secure, a lot more secure, in a system that does that than something which runs roughshod over all these rights and all these procedures.
Well, look, I think that's a great moment for us to open discussion to those of you who managed to get up so early in the morning. I am going to take one moment to recognize a few people who came to this event. One, I want to express my deep, profound appreciation that my friend from Syria, Mohammed Haikal, is here, thank God, and I only can extend to you not only all of our love for our Syrian brothers and sisters, but our prayers that the situation in Syria improves. I also want to acknowledge Cheryl Phoenix, who we have joined in a fight against the exclusion of black youths from schools in the United Kingdom, a fight against the mass incarceration of the black segment of our population here, which is even worse than the percentage of those incarcerated in the United States. And I'm very proud to say that through the efforts of Match solicitors, we had sadly nothing to do with other than paying their bill, we managed to stop an exclusion. And it's one of the few exclusions that have been stopped in the last few years. So Cheryl, keep up the good work. So I'd like to open this up for questions, for those of you who have questions. Yes? And could you stand up,
Yeah.
state your name, and speak loudly, please?
Yeah, Neil Barnett. When I was reading about this case earlier, I was puzzled about the question of a general backdoor being introduced. And you talked about it a bit, and the question, legally the question of one iPhone or all iPhones, but technically, unless I'm missing something, Apple seems to be disingenuous here. It'll take them 2 weeks and 6 employees to crack this phone. And then they're saying that they need to retrospectively re-engineer all future iPhones on the back of this in order to satisfy the government. And it seems to me that doesn't really add up at all. And is Apple just trying to make a general point here on the back of this case, or am I missing something?
You know, there's a serious concern, of course, that the technology in question could leak out, and I recognize that concern. I think the concern on the back door, I mean, they are being asked to create a backdoor to a particular phone. But I recognize that there is a danger whenever technology to decrypt is created, and I'm not naive enough to think that that's not a potential problem. Apple is very good, though, at keeping their secrets secret. I mean, as you all know, nothing goes on an iPhone that doesn't have the Apple signature. I mean, nobody can put something on it or take, and they have been able to safeguard that. I mean, that's the real keys of the kingdom, as it were, and they have done an extraordinary job of maintaining the security and the sanctity of that. If the government was asking Apple to turn over this software and such that it would even get out to the government, because like Bob, I'm not a big fan of trusting the U.S. government or any government for that matter. I've lived too long. You're almost starting to sound like Donald Trump there for a second.
Don't say that.
But no, seriously, I mean, there are risks to that, and measures need to be taken to make sure that does not happen. But I think Apple is quite adept at doing that. And by the way, this 2 weeks and 6 employees is their estimate. I mean, I've heard from a number of techies that they think it could be done a lot quicker than that and a lot more efficiently than that. But even giving them that benefit of the doubt, that does not seem like an overly onerous burden. But there's concern here. I'm not saying that this is by any stretch, impervious to falling into the wrong hands and aiding, but. Listen, hacking is not new. Hacking into network systems, which is where the real danger to me exists. It's not so much what's on your particular iPhone, because you can at least try to keep that secure. The problem is those that can hack onto our communications, our text messages, our downloading, getting that information. That to me is where the real danger exists, not in the ability of someone to have an iPhone stolen and have that, because at least should be able to hold on to that, just like Apple should be able to hold on to the software. Anyways.
David
Zykin, Judge Larson, thank you so much for coming. It's really entertaining.
Thank you.
And the question I have is that only few people have doubts that NSA has real problems getting into the phone and getting everything what they need to do. I think the only doubt is admissibility of this, and to me it looks like the fight is for ability for, in this case or in any other case, to bring this into the court, even if Apple resisting.
No, that's a good, you raise an interesting point. We have, for many years now, we have had what's called two sides of the house. In the FBI, in our intelligence community, there is a very strict line in American jurisprudence that information that is gathered for counterintelligence purposes, whether it's by the NSA, the CIA, the FBI's counterintelligence units cannot, under any circumstance, be used in a domestic criminal prosecution. And nothing in this case affects or changes that at all. In fact, the surest way, to play into the hands of a criminal defense lawyer is to introduce counterintelligence information in the case. It spoils the case. It kills the investigation. I love when they do something like that, because that on my client, it's over. It's done. I mean, that is pretty well established in the United States that can't go on. On the other side of the house, to the extent that you are using information or you want to use it, you have to go through the procedures, the requirements of the Fourth Amendment. You have to go into open court and establish with probable cause, based on an affidavit that lays out with sufficient particularity, with sufficient attribution and all the other requirements of a search warrant, and get a neutral magistrate to issue the warrant or the order. If that's the circumstance, then the information or the evidence obtained can be used. But it all turns on what procedure is used. What you're referring to by the NSA, that requires an executive order of the president, but does not require any of the judicial oversight that is provided for before one of these things can be used for admissibility of the court.
Peter?
Peter Binning. I just wanted to introduce a sort of UK aspect to this, because this debate is obviously being played out across the Atlantic, but at the same time we have an investigatory powers bill going through Parliament, which will require, if it comes into law, there to be a backdoor gateway for data companies and telecoms companies to allow the government to get into, through that backdoor, exactly the kind of data, as I understand it, that is at stake in this case. And surely that really does point out the problem that the All Writs Act is all very well, but actually it isn't a sufficiently specific law to require Apple to do this. I don't think it really matters whether Apple's going to take 2 weeks or 1 month or 10 minutes to do this. The law doesn't actually, at the moment, allow the FBI to go to a court and require them to do it. And that's the difference. It's not the same as a safety deposit box with some data in it.
You're absolutely right. There is no specific law that requires it. And so that is why at present it's a case-by-case basis for the courts to act. And the courts are using this All Writs Act not for the particularized purpose of the act, but rather for its general power that it imbues the court with to enact its orders. So the authority, as it were, ultimately it derives from the Fourth Amendment, the ability to issue a warrant that requires criminal evidence to be turned over wherever it is, whether it's on a phone or underneath your bed. I do anticipate that, like in the UK, the United States will, once we get through this rather crazy election cycle that we're in right now, will take this issue up. I mean, I think that there are some very strong political reasons why it's not going to happen this year, but I would anticipate this being something that Congress is going to have to address next year. One of the things that I found when I was a prosecutor back in the 90s and as a judge is that technology is always 1 or 2 or a factor of 10 steps ahead of the law. We're still using the legislation that governs wiretapping was enacted in 1968 in the United States. It's called Title III. That was when telephones had a big rotary dial on them, and they had a line that actually went, and the language of that act, which has been permutated and kind of modified to try to fit changing telephone technology, has really struggled to keep up with that emerging technology. But that's always going to be the case, and that's where the courts are called upon, kind of citing the language that I used earlier, to use a certain degree of common sense and reasonability and balancing of interests to try to keep up with the competing interests of privacy and law enforcement and national security. But I don't think any one law, whether it's the one being proposed here in the UK, legislation that come in the United States, will always be able to keep up with that emerging technology.
Well, if we're about to wrap up, I have one question to ask Judge Larson that I think would be of interest to a British audience, which has nothing to do with the Apple case. We are all horrified and agog by the fact that Donald Trump may become the Republican nominee for president. How can a man who spouts the language of 1930s fascism in a way which is now leading to campaign violence in the United States, the likes of which we haven't seen since the 60s. How can he claim the GOP mantle if you get into an open convention? I think what many people don't realize is there's a possibility you're going to have an open convention, because there's a very real possibility Trump will not capture enough to actually walk into the convention with a mandate. So if you have an open convention in the United States, you're going to have a situation where the powers that be in the Republican Party may actually be able to engage in some really strong tactics to deal with it. As an American, as a Republican, take a few moments to try to explain yourself.
Wow, now that was a question. That's a tough question. It'll be interesting. Tomorrow will be a decisive day. Or actually, today is Tuesday. Today will be a decisive day once it comes around in the United States, in terms of whether or not Trump is going to be able to get sufficient delegates prior to the convention or not. If he sweeps the states, the 4 states that are in play today, which I believe includes Ohio and Florida, he would probably have that. If not, it may very well be a brokered convention. But in any event, to explain Donald Trump is something which neither I nor I think any human being could possibly do. To explain his reception by the American people, I mean, I think there's 2 things at play. First of all, there's a tremendous, you cannot underestimate in certain segments of the American population the amount of fear and distrust that has been created for the government. And it's coming from different angles. I mean, I joked earlier about your statements coming from kind of a more liberal perspective, that you can't trust the government. And then you've got a more conservative perspective that for years now has talked about government overreach and government intrusion. And I think they've kind of come together. Donald Trump is not necessarily a creature of the right or the left. He really does hearken back to I don't use the word lightly, kind of this fascist prototype that we saw in the 30s or 40s, the strong man coming in and from the outside. And that's the second point. There is this deeply American perspective, and you see it in some of our Western movies, like High Noon. You see it in a few of the others where this strong outsider comes in and cleans up the mess and then rides off into the sunset. In California a few years ago, we elected Arnold Schwarzenegger to be our governor. I mean, you'll laugh, and it really is laughable. This guy's a weightlifter, all right, and from Austria. And this is who's going to be the governor of the state of California. Jesse Ventura, a World Wrestling Federation professional wrestler, whatever that means, was the governor of Minnesota. Every now and then we just, and now we've got Donald Trump, who is, to me, equally laughable as a president, is now being taken seriously. And it's somehow connecting with this, I don't know if it's uniquely American, but it certainly exists, where we just, there comes a point where we just get frustrated, and the Reagan-Bush era of Republican politics has come to a close poignantly with the passing of Nancy Reagan this week. This was a time when Republican politics were largely fiscally conservative, strong on national defense, socially conservative, but with a constant underpinning of trying to be somewhat enlightened. You had the 1,000 points of light of George Bush the Elder. You had the compassionate conservatism of George W. Bush. There was always this effort to try to reach out. Then that kind of gave way to the Newt Gingrich contract with America in 1994, and it became the Tea Party grew out of that, and it was like, well, we got to stop this compassionate business, and we got to be hardcore. That failed. And I think there was a view that even those people let down certain American folks. And so now we're in this third act of, well, forget all of them. Forget the establishment Republicans, forget the Reagan-Bush Republicans. You saw Jeb Bush just take a big dive. I mean, now he was the most well-funded, the most well-known. He was the candidate that I was supporting, quite frankly. I thought he was the most moderate and would have been the most reasonable person to be president. He just took a complete nosedive. And now we have Donald Trump, and the alternatives to Donald Trump are not that great either. I mean, Ted Cruz is a very right wing, and then we've got Bernie Sanders, who it's kind of hard to figure out, and I think he's resonating with the same kind of sense of just disgust with the way things are in Washington. And then we got Hillary Clinton. So I don't know. It's quite a mess we have across the pond where I need to return to. So thank you so much for the time this morning. This was really a privilege to come.
Thank you, everybody. Our next event will be in late May concerning lawfare. So we'll see you then.
That was very nice. Thank you so much. Oh my God. Crazy inside.